So it is 10:45 and we have a quorum. Let me call the meeting to order. Item 1 on the agenda, confirmation of minutes of the last meeting. If there are no comments on those minutes, let's confirm the minutes. Item 2. Let us invite the administration, and since the SFC representatives are also here, shouldn't we also now invite the deputations to come in? Could we ask the deputations to come in? Are they here? So we go into agenda item number 2. On behalf of the Bills Committee, I'd like to welcome the deputations for coming to the meeting today to express their views to the Legislative Council on the Securities and Futures and Companies legislation, Uncertificated Securities Market Amendment Bill 2014. I'd also like to welcome the administration and SFC representatives. Those who require simultaneous interpretation, please wear the earpiece and choose the channel of your preference. The channel buttons are in front of you. The list of representatives from the administration and the SFC has been tabled, and I will not introduce the representatives one by one today. 2 deputations are here. And there are 8 deputations which are not attending the meeting but nevertheless have submitted their views to the Bills Committee. First, this is the time for deputations to speak. We have ample time today at the meeting, so I'll give you 5 minutes each. After that, I'll ask the administration and the SFC to give an initial response. And then members can, of course, then ask questions of the deputations and the administration. The usual practice is that unless you state that your submission cannot be made public, we will upload your submissions to the website of the Legislative Council, and those have been issued to members as well. But if deputations have not submitted any views in writing, or if you have supplementary views, please let us have them as soon as possible after the meeting. I'll also like to remind the deputations that your submissions and your oral representation today will not be covered or exempted by the Legislative Council Powers and Privileges Ordinance. First, can I now ask Mr. Alan Tong, Chairman of the Federation of Share Registrars Limited, to speak. Thank you, Chairman. Good morning, everybody. I'm Alan Tong. I represent the Federation of Share Registrars Limited. Actually, on the 8th of September, we already wrote to the Bills Committee to state our views on the bill. I will just talk about 2 or 3 points today. The Federation supports the implementation of uncertificated shares. We support the bill. Well, I have been the chairman of the Federation for 8-9 years, so I know that the process has been long and I have been involved. Actually, in 2009, when the consultation paper was issued, we had already arrived at consensus with the SFC and the Hong Kong X, and that is we should go for uncertificated securities in this mode. 4 years have passed, and we have held numerous meetings, and now we are at the state of the legislative process, and we support it. I'm just worried about a few things. we have got the major direction, but together with the SFC and the Hong Kong X, I don't think we have arrived at the a shared view on the operation of the USM, say for example, dividend payment, etc. Who is going to do it? Is it going to be Hong Kong X or who? Actually, it should be by the SCC, or else today I think we have heard that the Hong Kong X would like to do it. My worry is if we have the bill, well, it could be passed all right, but then the actual implementation will still have to wait. It's just like you have boiled the rice, but you haven't got any meat or vegetable to go with it. According to the present timetable, if everything goes smoothly and with the updating or upgrading of the IT system, I believe the earliest time to launch USM may be around 2017 or 2018. If in the interim we still have to have meetings on the details with intermediaries, SFC and the Hong Kong X, and if we still have to discuss different matters and improve different things, the time will still be later. It is good to have the legislation, but I'm afraid we still have to wait 3 to 5 years before we have the actual market up and running. And the public will be asking why they have to wait so long. And certainly legislation is the easy part, but the devil is in the details. I'm talking about fees and division of work between us and intermediaries, brokers and banks. We only have a rough framework for cooperation so far. So I'm just commenting that we support the legislation, but we are worried there will be a big time gap between legislation and actual implementation. So should we thresh out more details with the relevant parties before we have a one-off kind of implementation, or do you want to do one thing and then another? Our federation is also worried that after we have the legislation, then it seems the pressure will be on us, and we may have to do a lot of adjustments and improvements. And then in the end, the USM may not be the same as the original model conceived. So I think that we support the legislation. I just like us to do the post-legislation work faster. I hope there can be a USM 2 or 3 years after the legislation is carried. Second deputation, Mr. Andrew Shen. He is not here yet. And the individual, Mr. Wang Yi-Wai, will not be here today. He cannot come. Should we wait for Mr. Andrew Shen? No? Okay, now let us invite the administration to first respond to Mr. Tong's views. The administration. We are very glad that the Federation also feels the need to introduce this piece of legislation and that it supports it. With regard to the details, the Federation, Hong Kong X and SFC are threshing them out. I believe they will look into all the fine details, and then the consensus will be the subject of consultation with the market players. There will be a high degree of transparency, and then we will start to work on the subsidiary legislation. This piece of legislation just provides the framework so that we can carry on from there. It is a very important step. Maybe the SFC would like to comment as well? Mr. Leung, Chairman, members, may I also respond to Mr. Tong's remarks? Those are the points carried in the submission already given to us. Mainly, there are 3 points. Later on, when we have the USM, with regard to corporate action, how should that be handled? That's the first point. Secondly, a temporal issue. How much time do we need before we can have the USM? Number 3, the details including fees and charges. Now let me respond to these points one by one. On corporate action, you may know that when we have certificated securities trading now, under the CCAS, all shares are held in the nominee's name. The average investors or brokers, their names will not appear in the company register. This is how it functions now. Later on, when we have USM, this mode will be changed, and holders will have the choice of holding shares in their own name or otherwise. Right now, all shares are held under the nominee's name under CCAS, and so a lot of corporate action will have to go through the nominee who is regarded as the legal owner. Investors or brokers right now cannot liaise with share registrars, because the share registrar represents the listed companies, and they are only in touch with the nominees who is the legal owner. One of the characteristics of the USM is that brokers and investors can now make a choice as to whether they'd like to liaise with the share registrars themselves. Now, if they don't want to, they can still make use of a third party who will provide the service. So, in considering the process, well, we have a working group, including the CCAS, Hong Kong X, and also the Federation, and Mr. Tong's Federation, that is. And we have been discussing the matter. We have heard both views for and against the proposal. On the one hand, the share registrars hope that if investors should want to do away with the middleman, we think that that should be allowed. In other words, we should not dictate that everything should go through CCAS. This is one aspect. So the choice will be left with the investor or the brokers.
And at the same time, we understand from the CCAS, well, they have tried to understand from the brokers what their views are, and the brokers are of the opinion that the present services be maintained, i.e. there is an organization which is coordinating the matters, and there will be acting to deal with the dividends and pass on the information and so on and so forth. So we know that we have to give a choice to the market. So in the future, we would talk further with both sides on how to proceed with the USM to allow the choices to the investors still to be there. So if we need to amend the legislation to do that, we would make the necessary amendments. So that's number one concerning corporate action. Second point on the launch time frame. Mr. Tong also said this earlier. We talked to the CCAS. CCAS will be the main operator of USM. They said they need around 18 months to build up the system. According to our present plan, if we start developing or building an IT system in the middle of next year, and if that takes 18 months, and that would take us to the end of 2016. And that also includes other support from the share registrars and so on. So by the end of 2016, the main system will be up and running. and then the operator have to test out the systems with the brokers and the market for several months. So conservatively speaking, around mid-2017, the trial of USM can be implemented. So that's our estimate now. So from now on up to that moment, mid-2017, that means 2 years or more. Well, we've heard views from the market that the USM should be implemented as soon as possible. When we built the IT system, we would be trying to work with the Hong Kong X and also the share registers to see if we can further compress the time frame. Now, the third point on the fees and charges. Well, we understand that this is an issue of concern of everyone. Now, what will be the model for CCAS in the future? What will be the fee level, and how would that be paid by the users? And and how the fees will be paid by those on the network? We have talked with the CCAS, and they said that in developing their IT system, all these will be taken on board. And at an appropriate time, CCAS will be consulting the SFC and the relevant stakeholders on this aspect. In our consultation exercise in our paper submitted to the LegCo, we said that as far as fees are concerned, there are several principles. First, the fees should be reasonable. And also, the fee should be commensurate with the services. And third, the fees should be at a level to promote the development of the USM regime. Now, if CCAS is to build a system, under the bill, any fees they charge have to be approved by the SFC. So the SFC will play a gatekeeping role. Thank you, Chairman. Just now, Mr. Andrew Shin has arrived. Perhaps we'll give him the time to express his view before we proceed with our discussion. Mr. Shin. Chairman, I'm sorry, because of traffic problem, I have arrived late. About the uncertificated securities market, we think that technically it is a simple issue. When we consulted our members, we found that there may be problems in our submission. We said that if I am a shareholder, then I have a certificate share at home. And then if there is dividend payment, the dividend payment will be mailed to me directly. Whereas if I do it through the bank, a fee will be charged. Now, if the dividend payment is not going to be big, then the fee will make a proportion of the dividend. Now, exactly on the day 27 years ago, the stock exchange announced the market will be suspended for 4 days. For many shares listed in Hong Kong, they are also listed in overseas market. Say for HSBC Holdings shares, if I hold shares in HSBC Holdings, if I have to trade it in the London Stock Exchange, we've asked the bankers and the broker firms. They said that we needed to present the paper share certificate to do the transfer or transactions. Well, our institute think that the Hong Kong X is already having a monopoly. So if the administration, that if we go by the USM system, we will be able to really monitor the Hong Kong exchange well enough. Second point, who is going to keep the records of the shares? Now, 27 years ago, we can actually use the share certificate to take out a mortgage. Can that still be done now if we have the USM regime? Also, does it mean that we have to deal everything through the Hong Kong Exchange? Well, Hong Kong Exchange is a good organization, but then when we looked at the history of Hong Kong Exchange, that might not be the case. But then for listed companies which are listed in overseas stock markets, they may have a longer lifespan than the Hong Kong Exchange. Now, if we don't have a paper record and then Hong Kong Exchange may be closed down for some reasons, one reason or another, for example, because of financial economy, what will happen to the shares of the investors or shareholders? So my question is, can we take out the physical papers from the Hong Kong Stock Exchange? And without a physical stocks or papers, can we still take out any collaterals, especially in overseas jurisdictions? And third, once or if in the unfortunate event of the Hong Kong Exchange closing down, will the investors' interest be affected? Will a USS system make it convenient for investors? Yes, I admit that. But for those who need to take out their, to get back their paper share certificates from the Hong Kong Exchange, they are people probably in the worst case scenario. Now, if we can address their concerns, that would be best. Say, if there is nuclear war going on, then investors are still allowed to take out the share certificates from Hong Kong Exchange, and then they can deposit it, say, at the London or New York Stock Exchange. If the investors can be assured of that, then that would be best. I'm not saying that Hong Kong Exchange will bump into any problems or difficulties. If investors are really wanting to go down that route, I hope that they can be allowed to do so. So, public officers, any response from you? First, I would tackle the point on stock markets in other jurisdictions. Now, Hong Kong is on a paper system now, but when we look at other major markets, they are on a uncertificated mode. They are moving towards the direction, for example, in Australia. In 1999, starting from 1999, they have already implemented a full USM regime. And in the United Kingdom, in the 90s, they have started introducing uncertificated securities, and they have been implementing a dual system all along. In the European Union, there has been a new development. They have passed a resolution or directive, and starting from 2023, IPOs are mandated to issue uncertificated securities, and by 2025, full uncertification will be done. And on the mainland, because it doesn't have a historical legacy, so it started out with the uncertificated systems. If Hong Kong's market has to link up closely with overseas markets, Hong Kong should move towards the direction of uncertification. That will be in line with their systems. That's number one. As to the U.S. regime, who will be holding the documentation or proof of shares and investment of investors? Well, what we plan to do is that there will be a transitional period. There will be a dual system, and some part of the market will be certificated and the other part uncertificated. So investors will be allowed a choice to adjust to the system gradually. So from the outset, it will not be the case that all securities will be made uncertificated. At this stage, in the shareholders register, there will be two parts. One is the certificated shares part, and that part will be held or compiled or overseen by the listed companies or the share registrars, they would be kept by them. And for the other part on uncertificated shares, that would be kept by the system in the Hong Kong X. So we will be moving gradually towards a USM regime. And then we'll be able to try out and see if the system is stable or not. And we would only wait till the market is ready before we implement a full USM regime. So that will be a trial scheme, so to speak. Perhaps for the other questions, SFC, Mr. Lui, do you have anything to supplement? Yes, I'll try to respond to Mr. Shin's questions. Ms. Chen also mentioned that what's crucial in the USM regime is that whether the computer can keep a record. Every company should have a company register or members register. And if that register can function well and keep the records, then that's very important. Because in the future, there will not be any certificated shares. So how can we prove that you are a certain shareholder? Then that will be done through that system. So it's just like the case of your bank account in the bank. The bank has a record in their system to show that you really possess a certain amount of money. You have the deposit. So that the same scenario applies to the USM regime. Now, in the international market, there is always a system operator, and in Hong Kong, the responsibility falls onto HKSCC. The bill also states that HKSCC will be directly regulated by the SFC in the future. And Mr. Shin mentioned the scenario of HKSCC winding up. Now, under the SFO, HKSCC must take into account public interest in their operation. So SFC will ensure that the company will work effectively in a stable manner, or else the market will be upset. And also the securities in the USM regime can be taken out for collateral purpose. So under, in the future, we would be talking with the market on how the whole thing will operate actually. We have 3 members wishing to speak. We have ample time, so I will not impose a time limit. Mr. Chan Kam Lam.
Recently, I have been in touch with people in the industry. Most of them support a scriptless market. Now, of course, there are voices in the industry saying that they still do not have full understanding of how the USM will be implemented, and they also have their worries. Mr. Tong covered part of those views. I'd like to ask the administration or the SFC, as Ms. Chan was saying, there will be a transitional period. There will be a trial period, and there will be phased implementation. In other words, the dual system will run for some time. I'd like you to give me a more clear timetable for the sake of the industry and the market, so people know exactly how long that process will take. As Mr. Tong was saying, please do not make people wait many years after the legislation is there, because people will be wondering where this is going. But of course, we know the fact is that we need the IT system to be fully tested and to be fully operational. I believe you need to tell everything clearly to the industry, because we need the cooperation. They also have to upgrade their systems so that they can do their part in complementation to the systems of the SFC and the Hong Kong X. So you have to give them a clear idea. And secondly, the market is worried about fees and charges. After we have the USM, even if the SFC will be monitoring the situation through certain criteria, or even if fees have to be approved by the SFC, however, if people are going to have to pay more than now, then people will ask the question, why go for USM? Because USM should bring advantages, and there should be streamlining in terms of administration, so why should fees go up? And people are now worried about this. If the administration or the SFC can give us the guarantee that fees and charges would certainly be lower than now, and that the fees should be set at a reasonable level, well, the new company is going to operate in or abiding by commercial principles. But what do we mean by fees at a reasonable level? I think we have to give the market a certain idea. If you do that, the market will welcome the USM even more. I hope the administration and the SFC can communicate more with the market and explain things to people. So apart from the legislation, there might have to be a code for the market, etc. And I'm just asking you to strengthen communication. Thank you. The administration, any response to Mr. Chen Kam-lam's remarks? Thank you, Chairman. I'd like to thank the member for his views. I'm very glad to learn that the majority of the industry support a USM. By having a phased approach, we would also like to shorten the transitional period as much as possible when the market is ready. But we need all parties to work together. And timing-wise, whether we can give a clearer idea to the market, as Mr. Lui was saying, the systems have to be upgraded, and that takes time. At the same time, the SFC and the Federation of Share Registrars and also the Hong Kong X, they are talking about the implementation mode. On the level of subsidiary legislation, the SFC is working hard. Hopefully by the second half of next year, we can have some public consultation. So the timetable is quite clear now at this stage, but as to the transitional period, it really depends on the readiness of the market. And then fees and charges. As Mr. Lui was explaining, there are a few principles. It has to be reasonable, and it has to be linked to the service level, and also it must promote and help the USM to be implemented. At the beginning, investors can actually choose to still hold paper shares or go for uncertification. And therefore, the certificated shares must be charging such fees and charges in a way so that people will prefer uncertificated shares. So the future operation mode will be for investors to have choices. That would help to bring fees and charges to a reasonable level. In our follow-up paper to members, we have mentioned that there could be 4 types of accounts for the choice of investors. And as for the operator of the USM system, the fees and charges indeed have to be approved by the SFC. The member also pointed out that we need to have a continuous dialogue with the market. We agree with that totally. SFC, would you like to say anything? Anything else? With regard to fees and charges, we understand that that is a major concern of the industry. We know that there could be new fees to be introduced because this will be dealt with through uncertification. So there could be a new fee, and we are going to take those factors into consideration so that the USM will be acceptable to the market. Yes, Mr. Tong, I'd like to say something about fees and charges as somebody from the industry. There will not be any sponsorship from the administration. In other words, the industry will have to work out their own sums. The Hong Kong X, of course, is wealthy. It makes a lot of money, so it has its own system. But as you know, all the share registrars are doing it for the shareholders. But then even if you have uncertification, we only have the same pool of clients. We won't have more shareholders. Well, if you ask us to invest in order to complement developments in society, is all right. But then in 2009, when we had the consultation paper, we also said that uncertification is really for transparency. We hope that the share registrars could be distributing dividends to shareholders so that we do not have to go through the nominee, but the Hong Kong X has disagreed. We want to streamline matters. We would like to distribute dividends to shareholders directly, but then the Hong Kong X is saying that since they have been doing it, they want to continue doing it. And this will have an impact on the fees they charge us. So in simple terms, we have worked a lot. We have invested a lot of money in order to launch the system. So, Mr. Shun, I'd like to tell you that even shareholders have to sacrifice something. You have to sacrifice that paper share that you have. You have to tear it up. And even if you have to tear something up, there could be a handling fee. But we are going in an international direction. We are complying with international standards. And everyone has to contribute to the process. It's just like environment protection. This is to help Hong Kong go international, and we support it. But we hope that we would also simplify matters in the interim. Listed companies and individual shareholders are paying to keep us alive. But we also have to upgrade our systems. And we have to do a lot more because we are going to have to serve more shareholders. So being an industry player, we are in business. We have to contribute a lot. I have had meetings on the USM for over 20 years. So we have already spent a lot of money and a lot of time, but still we support it. I am really saying that the timing should be done better. After you have the legislation, we should go for it as quickly as possible. Mr. Sin Chung Kai, I don't think timing is a big problem because we can have a commencement date for the bill. Supposing the bill is scrutinized and passed and the system has been tested, and then I believe the administration will come back for us to endorse the commencement date. So there will not be a question of the bill being commenced or the ordinance being commenced and then there is no market. I believe the dovetailing can be done well. As for fees and charges, I'm sure you would like fees and charges to be lower than in a certificated market. But then in any process, there could be some expenses at the beginning, and then you can only save up in the long term. So even if you don't like it, I am sure it's another case of seeing the disadvantages first before you see the advantages, because in fact you have to fork out money to upgrade the system at the outset. Well, however, objectively speaking, I understand there will be a delay of the Hong Kong-Shanghai Connect. Well, I don't know it for sure, but people are saying it. And the mainland has already got an USM. They might have started late, but they are there already. And if we are not ready, when they come and open an account, is it that we have to give them paper shares? And I'm not only talking about mainland investors. I'm sure there will be overseas investors coming to Hong Kong, and how should we serve them? I think we should look at the matter from this angle. But I'd like to ask the industry and also the administration this question. Mr. Tong talked about the distribution of dividends. Is it that the Hong Kong X is standing in the way? Why you don't allow share registrars to distribute dividends directly? Why does the Hong Kong X ask for another layer of distribution? The administration. Let me respond to this question on dividends. At present, under the law, the listed company will distribute dividend through share registrars to the shareholders. Under the present system, the CCAS holds shares as the nominee. So usually, listed companies will go through share registrars and then CCAS and then to the brokers. After we have the USM, the CCAS does not act as the legal owner of shares. It doesn't have legal title. And there is an issue here. Later on, investors can choose to face the share registrars themselves. The transfer of dividend can go directly into the brokers or the investors' accounts. And we are proposing that choice to brokers and investors. And as I said, some brokers have said to Hong Kong X or CCAS that they would like to maintain the present level of service. In other words, there will be a third party helping to deal with such corporate action.
So that's why that under the proposed model, two approaches are allowed. So the choice is up to the investors or the brokers, i.e., the investors can face directly the share registrars, which may not charge them. But if we do it through the CCAS, then the CCAS may charge a fee. So it's really up to the investor and brokers to make a choice. Are there any outstanding issues? Dividend payment is one aspect, and also voting right and rights issue. So this is part of corporate action. Mr. Kenneth Leung. Thank you, Chairman. When we go by the USM system, the certificated system will still be maintained, at least for a while. There are three functions: share registration, clearing, and settlement for CCAS, and also corporate actions. So CCAS has these three functions in these three areas. I would like to follow up on Mr. Xun's question. Among these three functions of CCAS, well, I think CCAS will monopolize clearing. What about share registration and corporate action? What room will you be leaving up to the market players to provide such functions? So what is the overall design of the model? Can you explain more clearly? clearing and settlement, I know that seekers will have a monopoly on it because your system is sophisticated. But what about share registration and corporate action? What room is there for the market players to take on those functions? Well, CCAS will continue to be responsible for clearing and settlement. Share registration, when the dual system is up and running, for the uncertificated part, CCAS will be responsible for maintaining the registration. The share registrars will be responsible for maintaining the certificated system. So with these two parts added, that will make up the entire members register of a company. Now, come one day when we have the full USM system, then it will be the seekers which will maintain the members register. Every day, the seekers will pass on the information to the share registrars, and based on the register, then the share registers will undertake corporate actions like paying out dividends and calling meetings of investors and so on. And third, corporate action. Is there any room for other market players to take on that role? As what I said, under the present system, while seekers serves all members, they have no choice. Other market players have no choice. But if we go by the USM, we will break or relax that restriction. The brokers and the investors in the future can choose to face directly the share registrars, or they can still use perhaps new services provided by seekers. So it's a question of choice and also the fee concerned. Well, I think from what I've heard, seekers really will be responsible for much of the work. Well, can you explain? No? Isn't it the case? Well, let me explain. If you look at the consultation paper in 2009, share registrars would be responsible for corporate actions. They are appointed by the listing companies to look after the shareholders. That's very clear. So the share registrars will be taking care of the small investors. Mr. Loy said the seekers, well, the system is called seekers. The nominee is called the Hong Kong SCC nominee. So we are giving out the dividends or passing on the dividends to the HKSCC nominees and not to HKSCC. So please don't confuse seekers and HKSCC nominees. We support the seekers to do the system, to take care of the system. They are not there to receive dividend on the investors' behalf. So the share registrars will be giving out the dividends to the shareholders. And then with the USM without the central nominee, then we will deal directly with the shareholders. But try not to confuse what we are talking about, this arrangement, with the system itself. Well, please don't get it mixed up. The share registrars are there to look after the shareholders' interest on behalf of the listed companies, including the corporate actions. While the HKSCC is just there to help with the distribution of dividends. The share registrars are responsible for corporate actions now. So I think we should take a cross-the-board approach, i.e. the dividend should also be distributed by the share registrars in the future. Ultimately, the seekers should be giving the share registrars on a daily basis the members register. So that will facilitate our work. A follow-up question. The EU has a set of guidelines saying that IPO offerings after a cut-off date should use a uncertificated system. Now, Hong Kong is to proceed with a USM in 2017-2018. Well, at that time, we will still be giving the investors choice of USM or a certificated system. So my question is, when we'll get a full USM system? Can you tell us a timetable? We will consider IPO as the first priority for implementing the USM system. That will help us in facilitating the implementation of the system. Well, you don't have a fixed timetable yet? Would you be setting, say, that once the bill commences operation, then all IPOs have to be in USM? No, we can't say that. We have to make sure that the market is ready. And when we first implement the system, there will be trial points or trial schemes first to see if the system is running smoothly first before we proceed with implementing the system in other sectors. I don't have any more questions. Mr. Shin, any views from you? Chairman, the administration hasn't answered my question. If I buy shares in Hong Kong and the shares are listed in, say, 2 other international stock markets, can I take back the paper shares with me? Now, well, that can be done now because we are still on a paper system. But if it is going to be a USM system, can I still take the shares, the paper shares with me, take it back from the market? I think a paper system is stable, and I, as an investor, have the right to really take back my paper shares. When I spoke for the first time, I raised this question, but I don't think the government has given me an answer. And this is a very important issue for the investors. That is, I would like to have my paper shares back when anything untoward happens in the market. So, can the administration tell me that if there is a USM system, can I take back my shares and then take it to be transferred or traded on the London Stock Exchange? Sorry. Well, you can certainly now take back your paper share certificates. Now, if a USM system is in place, well, you can still do that. All you have to do is to work through the market players, and the market players can use an electronic form to help you trade or help you undertake transactions in an electronic format, a paperless format. That can be done, of course. Has that mechanism been set up? Yes, that's what we are considering. Trying to turn everything paper forms into paperless. Chairman, the administration obviously hasn't set up that mechanism. Well, it seems that the SFC and the government try to evade that question. I'm afraid that's what's going to happen. That what happened at competition bill will happen here. That things are not ready yet. Well, I mentioned about the tragedy 27 years ago when the stock market was suspended for 4 days. And when the government draws up policy, they are acting like technicians. And they are not going through the rationale behind all the systems. And they are adjusting the system as if they are technicians, and then there are a lot of loopholes. And back in 1987, the system was not yet in place, but then changes were implemented. So if the government has not been able to allay the worries of the investors, please don't implement the USM. Well, if you talk about 2023 in European Union, they are mandating the certificated system in 2023. We don't know yet whether the European Union will still exist in 2023. So, Chairman, Mr. Kenneth Leung seems to be interested in answering your question. So, government, can you explain clearly how the entire mechanism works? In my professional occupation, I have been providing advisory services to security firms. And I would like to know what Mr. Shin said. Now, if I'm a small investor, I would like to transfer my shares or clear my shares in another stock market in another place. How can that be done? That's question number one. And number two, in financial services, there may not be international standards. Well, say for universal suffrage, there may be international standards. In the aviation sector, there are international standards as well. And in the financial sector, we do have a lot of international standards. I am sure that the chairman will agree with me on this point. It's difficult, perhaps, for the SMEs to comply with international standards. I think the government should lend a helping hand to the SMEs. So there are international standards, not only related to universal suffrage, but also, say, in the financial sector and financial services. There are minimum standards. So if we want to do business internationally, we must comply with the international standards. So SFC, have you projected that for a small shareholder, if we have the USM regime, will it cost him more or less if he's going to do a transaction? And also, what does the stock exchange, what functions does the stock exchange serve apart from investor protection? Will USM be related to the stock exchange?
Is it Mr. Lui? Let me kickstart with a reply. An investor holds shares of a listed company in Hong Kong, and he wants to take the shares to the UK. Do you mean that he wants to trade those shares? It may be two kinds of shares of the same company, and both holders are shareholders of that company. So he doesn't want to trade in Hong Kong. He wants to do it in the UK or elsewhere, as long as there is a listed market. I think the first thing to note is the memorandum and articles of association of that company. You have to look at that to see whether the listed shares of different places can be transferred or not. Now we have H shares and A shares. They may belong to the same company, and it depends on the legislation in place. Apart from the M&A of the company, you also have to look at the legislation of the different places, whether such transfer is possible. And if yes, Mr. Tong has said that actually share registrars also provide the service. In other words, the shares can be transferred to another shareholder in another market. This is done now in the paper market. Later on, it should be the same, even when we have the USM. So the most important thing is to understand the memorandum articles of association of that company and also the legislation of the different places. The member also talked about stock levy charged by the Hong Kong X. We need to take this up with the Hong Kong X because all in all, the stock levy is premised on trading. But now we are talking about settlement and clearance. That may be the subject of another fee. Of course, if there is trading, you need to have settlement and clearing. It's part and parcel of the same process. Now, under USM, we also talk about the process of the transfer of shares. It may be related to settlement and clearing, but this can be done among investors. So that issue is broader. I'm not saying that this is not related. There is a relationship here, and we can seek an understanding with the Hong Kong X. Okay, members and deputations, any more views? We still have time. If not, yes, Mr. Sin Chung Kai. After listening to Mr. Loy, the SFC, you don't need to defend the Hong Kong X. Is it that the Hong Kong X is acting like a bad loser? Is it that they only want to have the advantages and the disadvantages would be pushed onto the industry? I think they should come here and explain things to us because we see a great discrepancy. If the SFC cannot answer, maybe the administration can answer. If the administration has no answer, the Hong Kong X should come here. Who will respond? Well, we can ask the Hong Kong X to come here because they know that there is this meeting. Okay, let's invite them to come here. I'd like to ask why today the Hong Kong X is not here since every other party is here. Well, you can write to Mr. Charles Lee, the CEO. Well, it's not for us to say it, Mr. Chairman. This is an issue that has everything to do with the Hong Kong X. It should be represented. No, Chairman, you are the Chairman. You should not ask us to write a letter. Mr. Tong mentioned a few points, and I think they should be followed up. Mr. Loy, I understand the SFC has its views, but I believe it will be better for the Hong Kong X to come here and talk about the discrepancy and why it doesn't want the share registrars to provide a one-stop service. Of course, Mr. Loy also said that you want to provide a choice. But why only a limited choice? I think these questions have to be answered. Since we are scrutinizing the bill, we would like the Hong Kong X to come here. No, we are not hoping Mr. Charles Lee will listen. This is a bills committee. You can summon them to come here. I elect you to be the chairman. You have to do this. You just have to write a letter, Chairman. We can write it on your behalf and then you send it out. Yes, Mr. Shen, a brief one. I am a commentator, a financial commentator. Those of us who have been investing in gold and platinum, we are a little paranoid. We always talk about physical delivery. I understand that Hong Kong is an offshore banking center, and we have been that for over a century. Many people come to patronize our financial services, even if we don't know exactly the assets of the market. If we can preserve physical delivery, I believe when the mainland starts to go scriptless, they may even think that this is an advantage in Hong Kong because there could be physical delivery instead of leaving everything with the government. The world is pessimistic. When the world was in chaos, assets and capital came to Hong Kong because we all still had the option of stability. I know technologically wise, it it can be done and it makes things simpler. But in the worst case scenario, people would flock to Hong Kong. This will add to our competitiveness. This is my final comment. Thank you. Okay, any other comments? If not, yes. If we preserve our approaches, which are not exactly transparent, we are now compelled by other people to be more transparent. G8 and G20 countries are asking us to automatically exchange taxation information, etc. And under such pressure, somehow we have to budge a little. But then, on the other hand, we want to preserve our uniqueness, like our taxation system. But as to the transparency of companies, now as an asset management center, now let me digress just a little. How should I put it? If there is a certain degree of non-transparency, whether legal or not, then people would come to Hong Kong for asset management. But this is not the way to go. This is not the world trend. I'm sure many overseas asset management centers like Cayman Island, BVI, they are under huge pressure, especially those from the US and the EU. They're asking for more openness and transparency. There is no final view yet, but then that may be the international trend. Yes, we can resist the international pressure, but I'm not sure for how long we can do it. I'd like to respond. Talking about higher transparency, this will only allow the government to know the assets of citizens more. But you should talk about privacy, defending the privacy of the citizens. Maybe you should look at it from that angle. Chairman, yes, Sin Chung Tai. I did not want to speak, but since we are on this, in fact, a paper market has its own disadvantages. The thing is, you can lose the documentation. The registrars may have a record, but times have changed, and sooner or later we have to go scriptless. It's just a matter of time. Okay. Yes, Mr. Tong. Since Hong Kong X is a major player in this, since it also heads the working group, but then the reply to the consultation paper is confidential. We can't see that. I don't know why. I want to know its reaction, but it seems the reply submitted by the Hong Kong X cannot be made public. Is that the case? The administration, what is your view? From the Secretariat, we came to know that the Hong Kong X response is confidential. But I think your clerk was in contact with them. Thank you, Chairman. Let me add. On our website, we issued invitations to the public for them to come today. Submissions of deputations will be made public if there is no particular request from the deputations, and members could see the written submission of the Hong Kong X. But when it was submitted to the committee, it was said that it would like to keep it just within the committee. Okay, if there are no other views, I'd like to say something about the industry as well. I declare I am the boss of a brokerage. We have had some detailed discussion on this issue of USM. Generally, we support having USM, but we are concerned about two things. One, timing. Two, cost. On timing, if we go for USM, we should do it within the shortest time frame. The transitional period should not be too long. We agree that once we have IPO, we should go for an uncertificated market, because if brokers hold the shares on behalf of clients, then there would be an account for USM and also another one for certificated market. And we have to combine it, and then there would be a lot of administrative fee generated in terms of our holding the position. So we would like the transitional period to be as short as possible. And secondly, can the administration consider sponsoring us in upgrading our IT system, or else the cost will be a heavy burden? We hope the administration can consider this. This law applies to Hong Kong companies, but amongst the 1,000-odd listed companies, there are not many Hong Kong companies, and we have to think about that. Well, later on, the administration should consider including companies listed overseas in the USM, and I want you to do it with a tight time frame. Well, you have to talk to other countries about the legislation. We are already scrutinizing the bill. Well, but other countries might not have the same kind of legislation. Okay, any other views, any other comments from members? If not, our meeting will end here. Is it that we are going to have a further discussion with the administration after the deputations are gone? The deputations, please feel free to go. We'll continue with the meeting. Thank you. It is now 12 o'clock. We have our meeting until 12:45. We should look at the follow-up issues arising from the last meeting. Is it that the administration will walk us through the paper, and then we'll ask the committee whether we would have further comments? Yes, Chairman. Let me kickstart, and then I'll defer to the SFC to walk you through the paper. The bill is for amending the principal legislation. We are going to set up a supervision framework for a USM. The details will be set out in new subsidiary legislation.
As to the operation mechanism, we did discuss that. The SFC is working out the technical details of the operational model with the stakeholders, and the SFC will consult the public in due course. Last time, members asked how the proof of share ownership for trading transfer can be done. Under our proposed mechanism, investors can choose to record his securities in his own name or do it through a nominee. Well, a nominee can be a bank or a brokerage. Perhaps I'll defer to the SFC colleague to explain what types of accounts are available for the investors. Thank you, members. Responding to members' questions raised last time, we have already prepared a paper in response. Please, may I refer members to the annex of the document, and we have a diagram showing the proposed uncertificated securities market and the accounts therein. As what Ms. Chen said, throughout our consultation, we explained to the market players that in the USM, investors can hold the shares through a nominee, and that they can hold it in their own name as well. May I refer members to Annex? On the very left, there is a small box, and that is the CCAS participant account, CPA. What can you give us the number of the document? Oh, all right, CV1 2035-13-14 Well, there are 3 pages to this document, and the annex is in page 4. Now, in this diagram, we have this CCAS participant account, CPA, that is the broker's account. So in future, the investors can choose to hold the shares through the broker. Now, just like what they are doing today, they trade shares through the broker, and then the shares are held in the name of the broker. So if they want to do it through the CPA account, well, that can still be done in the future. USM. Now, the investors can hold the shares in their own name. There are different types of share accounts from the very left, and that is a CCAS participant sponsored accounts, PCS, and then investor participant accounts, IPA, and also on the right, issuer sponsored accounts, ICA, ISA. They will be providing different services. The common characteristics is that in these accounts, the shares are held in the investor's name. Now, they are holding the shares directly themselves. So if this is the case, then they would be trading in a different way from what they're doing today. Now, as the shares are held in their own names, what they need to do is they have to transfer their shares to the CPA. In other words, vice versa, if they trade shares or buy in shares through the CPA, then they need to transfer the shares from the CPA to their own accounts. So that's the major difference from the practice today. If you want to hold shares in your own name, you have to take an extra step. You have to make transfers between your own accounts and the CPA. So that's how the transfer and trading will be done. Well, members have also raised questions last time, which were discussed just now. Well, perhaps I'll give you a brief response irrespectively. Last time, member also asked that in the future, how you prove your ownership in shares under USM. As we explained before, the CCAS will be holding the register for the uncertificated shares, and that is going to be a proof of your ownership of the shares. Members last time also asked about technical questions like how a dividend is distributed, and also if brokers are going to provide margin financing, how can that be done? These are technical issues, and at present the SFC and the Hong Kong X and also the Federation of Share Registrars are in our working group. We are discussing all these issues, i.e. the operational model of the USM regime. When we are finished with our discussions, we would consult the market. Just now we also discussed how shares will be traded and so on, so that we will continue to discuss that with the market very soon. Member also asked about shareholders' information, say their names and other information such as amount of shares owned. What are the requirements? In our written response, we said that the SFC will issue rules on the type of information that should be kept by the register, and also what kind of information should be made public. So that will be dealt with. Under the present company ordinance, there are basic requirements, i.e., every company should keep the name and address of a shareholder as well as the number of shares held. So in our rules, we would have regard to the requirements under the CEO now. So in consulting the market on the subsidiary legislation to be drawn up, we will certainly communicate with the market players on those. So much for my response. Mr. Sin Chung Kai, I would like to ask about the timetable. Ms. Chen, you have the principal legislation now. After we are done with the principal legislation, we will proceed with making the subsidiary legislation. Is it the case that when the principal legislation amendments have been enacted, then you would proceed with the subsidiary legislation, and then you come up with a commencement date? Or what is the process? What is the timetable? Thank you, Mr. Sin. Well, as Mr. Sin's understanding is right, first we'll deal with the principal legislation, and then in the second half of next year, we would consult the public on subsidiary legislation, and then after the consultation, we would then draft the subsidiary legislation and take it to the LegCo for scrutiny. Now, what we're doing at the same time is that we would be continuing with discussions on the operational details, and that will be done on the platform of the working group with the Hong Kong Exchange, Hong Kong X, and also the Federation of Share Registrars as members. If we are able to forge a consensus on the operational details, then we can proceed with upgrading the system. Mr. Lewis said that Hong Kong X says that it needs 18 months to upgrade its system. And we can do that before the subsidiary legislation is passed by the LegCo. We can do that at the same time when the subsidiary legislation is being drafted. So, based on what you said, the earliest time that the system can be implemented is 2017. Is that right? Yes. Questions from members? So that will be the end of the meeting today then. AOB. The next meeting is 10:45 a.m., 17th of November. Can we ask the representatives from the Hong Kong Exchange to attend the meeting? I heard your views. I'll write to them. Thank you. Thank you.